Well, welcome and good afternoon, everyone. I'm Bob Clifford, founder and senior partner of Clifford Law Offices here in Chicago. This is our 17th year of conducting this program, and the Clifford Law is very proud to once again offer a quality continuing legal education program offering 2 hours of free professional responsibility credit. More than 5,000, I think we're up to 5,300 lawyers are registered from across 5 states in the region, which I believe makes this the largest CLE program of its kind in the country. And I wish to thank all of you for being here today. We see the registration list and we see many return friends, and I'm gratified by that very much. Hello, Miles Bierman. Good to see you. Always have to have a shout out, buddy. I'm committed to the idea of raising the quality of the practice of law, both here in my office in Illinois and elsewhere. And in addition to promoting civility and goodwill among lawyers, it's very, very important. And it's very important that we teach that to our young new lawyers. And I hope that programs like this, a very timely program, achieves those goals. And it's another step in that direction. Today, we are presenting questions from the trenches. After last year's program, we reached out to many of you and asked for your input about what were ethically important issues in your practice, and you responded. And we tried to put together a program today that's based on that. Joining us are 3 outstanding panelists in the area of law. We have Kevin Hopkins, ethics professor at UIC School of Law here in Chicago. We have the Honorable Mary Cay Marubio, presiding judge of the Pretrial Division in the Cook County Circuit Court and a member of the Illinois Judicial Ethics Committee. And then also Melissa Smart, Director of Education and Senior Counsel of the Attorney Registration and Disciplinary Commission, our ARDC. Thank you all 3 for being here. You've been wonderful to work with, and we are very grateful for you being here today and all that you've done to be prepared. You can find out more about our panelists and their bios that are included in the materials that were distributed to all of you. We encourage the thousands of you listening today to ask questions. Everyone watching is muted, so please send your questions in writing as you were instructed in those materials, and we will try to get to as many of them as we can. There are materials accompanying the program that you received electronically with your registration. Also, to increase interactivity, we will be asking a series of polling questions. You can submit answers to these questions in 2 ways, visiting pollev.com/Clifford Law from your computer, or by texting Clifford Law to 22333. That's once again Clifford Law, and then send that to 22333. And that allows you to join the polling session, and then you text the answer to each slide that comes up. We will have these instructions listed on the slides, as well as the frequently asked question posted to our site. So without further ado, I turn to our first hypothetical. So please turn to those hypotheticals. And once again, these are based on real issues brought to us by all of you. Jane, who's a partner in her own firm, settles an elderly client's personal injury case for $25,000. After the case settles, but before the funds are distributed, the client passes away. Jane intends to deposit the $25,000 into the firm's IOLTA account for the now deceased client, who, by the way, left no will, died intestate. There, however, the firm had changed its computer system, and unbeknownst to Jane, the computer system never deposited the $25,000 into the firm's IOLTA account. I had a question about how that happened. Where was the money? Sitting in the drawer? Can't have checks sitting in the drawer. Anyway, 2 months later, Jane is ready to close the case when she realizes that the money was never properly deposited into the IOLTA account. No one has complained to her or the firm about claiming any of the proceeds. Judge Melissa, do you have, is Jane responsible, given that she took all precautions in keeping the money in the IOLTA account, and it was a computer software glitch to fail to transfer over to her dollars? Is she responsible for that? What do you think, Melissa?
Well, Bob, I agree with you. It definitely cannot be keeping any of those checks in the drawer, that's for sure. And this kind of begs the question as to where that check was. But I have a feeling we're going to get into that. But the reality is that regardless of the computer glitch or not, the attorney themselves is responsible for making sure that that check is properly dealt with and managed. Those client funds are properly managed, and that's articulated in our rules 1.5 and 1.15, which in Illinois were recently redrafted pursuant to our plain language initiatives by the Illinois Supreme Court. But those two rules make it plainly clear that the attorney themselves is responsible for maintaining the integrity of those funds.
Right. I have to tell you, when I read this scenario, what came to mind, and was true back when I heard it in law school in probably 1974 or 5, from then Judge Daniel Ward of the Illinois Supreme Court, no co-mingling. So aside from checks sitting, you can't sit in the drawer, I sure hope that this check didn't make its way into the firm's operating account, because that would be commingling, I believe. And so
Absolutely. Those rules require that the attorney maintain the funds in a separate and identifiable account, and the separate part is the no commingling for sure.
our next related question is, look, 96%, I don't agree with us. There's always a few outliers there, 5% or so that think otherwise, but that she's not responsible. But I don't think the law would go that way for her. So now, next polling question, though, given that the money was intended to be deposited into her IOLTA account, Jane did not report any interest on the $25,000 to IOLTA. Does she owe interest on the money? Yes or no? What do you think about that, Professor? She have to go deep. She have to deep into her pocket and put a little money into the game. I'm not hearing the professor, Joe. I think
Sorry about that. I would think so. The account that she should have put the money in would have been an escrow account, getting, acquiring interest. And so I think the client would have been entitled to that interest.
Well, I don't want to get us too off track, but that's an interesting question, because the IOLTA account itself, normally those proceeds go to the benefit of the court. Now, of course, we have this new ability to have funds escrowed to the benefit of the client. I don't know, Melissa, where's Jane supposed to put this money if the professor's right?
Well,
Who gets the money?
that's what I was kind of getting at as it relates to where the money was in the interim. I mean, it had to have been somewhere. If the computer glitch occurred, the funds had to be somewhere where they sat in, they were never withdrawn from the insurance company, whoever issued the draft, or, those funds had to have been somewhere. Now, as it relates to the interest on the money, all the rule requires is that the interest does not inure to the benefit of the attorney. Now, certainly, had it been appropriately placed within the IOLTA account, that interest would have been swept out pursuant to the Lawyers Trust Fund program, in which the interest is pooled and pulled out of the larger grouping of funds. But in reality, I'm not sure that from a disciplinary perspective or the rules of professional conduct, that there is interest owed. Now, should there be beneficiaries that pop up that have a claim to those funds, they may have some kind of a civil claim to redress that grievance that they needed or were entitled to some kind of interest. But in this type of situation, I'm not sure any client would have necessarily been deserving of interest if that would have been placed properly in an IOLTA account and considered short-term and nominal funds, as IOLTA account funds are required to be.
Right. Okay, well, moving on then, I think also related question, can she keep the money and put it in her own account? I mean, is there any doubt about the answer to that question? That's gotta be a resounding no. Although someone says yes, as long as she places a legal ad seeking out the heirs and no one responds, and no, she needs to hold it into her IOLTA account regardless of the death of the client. And then finally, another option, no, she must take reasonable efforts to identify the rightful owners of the funds, and her efforts are unsuccessful after 36 months, remit the funds to the Lawyers Trust Fund of Illinois. Professors, that sound like a good answer to you?
I would go with no, that she would not be entitled to keep the fund. put them to keep that money.
But what's she supposed to do with it?
I think she has to place it in an account at least that's set aside for the client.
Is there any Melissa? Is there any magic to the 36 months wait? I mean,
There is, as a matter of fact, Bob. Sorry, I didn't mean to interrupt you.
no, that's okay.
We publish a brochure called the Client Trust Account Handbook, which is now available on our website, and that one gives specific direction. Additionally, the Lawyers Trust Fund of Illinois, pursuant to the legislation that was passed in relation to kind of funds that are unclaimed, regularly specifically indicates that after 36 months of an unsuccessful attempt, that the money would then go to Lawyers Trust Fund and be treated as almost like an unclaimed property type of a situation. The clear-cut answer here is the attorney cannot take those funds and benefit from them. What to do with them, though, if an attorney ever has doubt, they should take a look at that Client Trust Account Handbook, because in Illinois specifically, it gives some really good guidance on our IOLTA account program. But specifically, it states that if you've made reasonable efforts to identify the client and been unable to do so, then you should remit the funds after 36 months to Lawyers Trust Fund. It also gives some guidance as to what is considered to be reasonable efforts. In this day and age, some level of a little bit of sleuthing is required in order to fulfill your obligations to reasonably make an effort to identify the rightful owner of the funds.
Right. And for me, the moral of the story is that, look, it's not to the lawyers. Remember the words of Justice Ward. It's not your money. You can't keep it. Don't commingle it. Don't keep it. That you will always be safe to entrust it to the Lawyers Trust Fund of Illinois. Well, let's move on to hypo number 2. We have a dozen hypotheticals today, by the way. Number 2, Kim's client is a U.S. military veteran suffering from PTSD. Generally, most communications between them, Kim and the client, regarding his employment discrimination claim involve abusive language and yelling on the part of the client. Kim tries to listen attentively and remain calm to administer sound legal advice, but she is unsure that he is listening or is able to make sensible decisions based on given the compromised state of his health. This is a question that I'd like all 3 of our panelists to discuss, but let the polling proceed. But should Kim, number 1, A, tell the client she will withdraw from the matter unless she can speak to her family and calmly? B, ask that the client have a mental health counselor present on all in-person or phone visits. C, petition the court as to how best to handle this pending claim. D, give the client 3 warnings in writing and then tell him he needs to find other counsel. Or E, immediately withdraw from the case because it looks like a lot of trouble down the road. Or F, get the client's written permission, allowing Kim to sign all necessary documents so as to minimize these encounters. Judge, what's your reaction to all of this? You have a history in the family law courts, I know. You probably have seen analogous situations to this. How would you recommend the lawyer handle these things, Judge?
Yeah, absolutely. My experience in family law tells me, and it has really helped shape my opinion on this. There's a really fine line between someone who has a mental health issue, a mental health crisis, and who is just being an obstructionist or oppositional for the sake of being so and being a high conflict litigant. And in this instance, with this fact pattern, it's clear that this person may have some cognitive issues, some mental health issues that need to be addressed. And if this is happening in the courtroom, within the purview of the judge, then the judge has an affirmative duty to address it, because the judge has a responsibility to require order and decorum in the courtroom and in all those proceedings, and especially if it's getting in the way of resolving the case or moving the case forward. So I would, if that attorney came to me, as the judge, petition the court as to how best handle this, I would intervene and inquire if we can move the case forward in any way.
Yeah, Kevin, let's give the client here the benefit of the doubt, knowing that it is a PTSD claim. How about, what does the Illinois rule of professional conduct 1.114, client with a diminished capacity, tell us? How does that inform us here about how to proceed?
Well, I think that it gives us the opportunity, or would give the attorney the opportunity to go to the court and to petition possibly for a guardian on behalf of the client, if in fact the client has, a diminished capacity, and in the fact pattern that looks like the client is suffering from post-traumatic stress disorder. So the attorney could do that. As I was thinking about this question also, under Rule 1.4, there's an obligation to communicate with your client to the extent that you can. And if in fact you're unable to do that, I do think that the diminished capacity rule would apply. And then finally, with regards to the client yelling at you and all of that, just as just a part of professional courtesy, I think, would allow you to kind of stop that client and tell the client that, we're not going to proceed any further until you kind of get yourself together, or, the client. Mm-hmm.
I think I have to say that from the perspective of how we handle these things here, every case, of course, will vary. I mean, here you do have someone who your fact pattern tells you that there is a PTSD issue here. So I think the lawyer, probably needs to be a little bit more open-minded about how to proceed. I mean, as a general proposition, we won't tolerate clients yelling at our lawyers or staff. And I don't think the bar has an obligation to do that. There are abusive people, there are obstructionist people, and they just think that since you're working for them, they have the right to be abusive to you. But I don't. This is a different situation. And I can tell you, for an example, in the Boeing litigation, where we have clients from 35 different nations around the world, in the Boeing MAX 8 litigation, there you have people who don't understand the legal system here in the United States, and they get frustrated. So each of these things, I think, it needs to be evaluated into the decision. Melissa, do you see things like this at the ARDC, and how has the board typically dealt with it?
We have, and it's unfortunate, but I think you all kind of hit the nail on the head that it's a very cautious approach is the best approach to take in these types of situations. Obviously, an attorney does not have to be, a glutton for punishment and take kind of abusive behavior from any client, but certainly given the nature of the matter and the attorney's knowledge that the client is a military veteran who has been diagnosed with PTSD, especially in this day and age where mental health and well-being is at the forefront of what we do in the legal profession, I think attorneys are well served to try to proceed as normally as possible with the representation of the client in that scenario. And that's exactly what Rule 1.14 tells us, is that a lawyer should proceed as normally as possible through the attorney-client relationship. And while the yelling and abusive language is unfortunate and certainly factors into it, I think the more telling aspect of this particular hypothetical is whether or not the client can make sensible decisions, and whether the client loses that ability, or the lawyer believes that the client no longer possesses that ability. That's when it rises to the level, as the professor and judge have pointed out, to maybe you need some intervention. You either have to, get before the court on some motions and matters, have a guardian appointed, speak to someone who has a power of attorney over this individual. But absent that, I certainly think that it would be well within the purview of an attorney's rights to say, hey, I'm going to withdraw if you continue to be abusive to me. But again, while also acknowledging that in some circumstances that, well-meaning people sometimes suffer from matters in which they can't control their tempers and whatnot, and that, maybe providing a buffer by way of a guardian might be the best way to go.
That's right. And Joe, bring up the polling answers if you could, so we see that. But apropos to what Melissa just said, in a recent incident, we had this issue, and one thing I learned, you learn something new every day, no matter who you are, is that sometimes clients misunderstand this issue about the appointment of a GAL. Some of these cases are so emotional for people, it impacts their judgment and their ability to make clear judgments. And some folks confuse that they think that you're accusing them of being of unsound mind, and that's not the case at all. It's just that the emotion associated with the event and the decision making is just has impaired their ability to give clear judgment, and that's not a rap on their own mental health either.
Can I add
yes.
something to that?
Yeah, please, Judge.
That got me through my stint in family law. It was a series of books by a licensed clinical social worker and attorney named Bill Eddy, EDDY, and it's about dealing with high conflict personalities and learning how to de-escalate situations. And I think as attorneys, we probably don't have enough training on interacting with people who are having emotional outbursts, whether that be caused by anger or a mental health issue.
Right.
And it's a really great series of books for professional development.
Right.
We do have a question from some questions are coming in, and one says that, would you see any problems, do the panelists see any problems if the parents are adverse to each other and they're represented by their own attorneys? However, the father, represented by a court-appointed attorney, David is asking here, is paying the attorney for the mother. So is that going to be an issue when in a case like this? Melissa?
Kevin, what do you think?
Kevin?
Well, off the top of my head, I think that with regards to the client, well, with regards to fees and payment of fees, the client is going to be the person that's you know, the client's going to be the person that is going to warrant the not the protection, but the representation. And so no matter who's paying for the fees, still the representation, the loyalty of the representation is to the client and not to the person paying the fees.
I note in our polling that you know, less than half, but a strong preference would be to tell the client about withdrawing, that you're going to withdraw unless they can speak calmly. I strongly endorse that, and I think it's effective. And the second one, of course, is, you know, petition the court about how to best handle. I mean, it's all, that's why the courts are there. The courts are there to help you properly administer the litigation or the matter that's in court, and I strongly endorse that as well. Frankly, I think you put the two of those together. Do you tell the client, hey, I'm going to be withdrawing here if we can't, you know, do this calmly, and at a minimum, I'm going to go into court, and who knows what a judge is going to do. A judge may well appoint a guardian. Why don't we try to put those things into perspective and calm down and see if we can move forward? That's usually works reasonably well in these situations, at least, and that's my experience with it. Well, I think we got out of that what we can. Judge, thanks for telling us about that book, the Bill Eddy book. It's noted in the materials, folks. Okay, moving on. Number 3, Brad, a new associate at a large firm, has been assigned a last-minute motion on a complex case. And although he is familiar with the issues, he wants to be sure that he makes the deadline and produces the best product possible. So what's he do? He goes to ChatBOT and has the artificial intelligence AI platform write the first draft. After reviewing the 1,000-word document, Brad is actually quite pleased with the result and turns it into the partner who files it with the court. No mention of the source of the writing is discussed. Polling questions, of course, will come back to our panels. Does Brad have an obligation to tell the partner that he is not the author of the motion? Wow. And then also, well, let's start with that as our first polling question. But I'm anxious to hear what Judge and Kevin have to say about this one.
I love that it's 98% that are saying yes, that they're seeing immediately that you know, there's an issue here. These AI issues are going to be coming at us fast and furious over the next few years. In this instance, you know, at a minimum, Brad's got to disclose that and have exercised some diligence, right? That's one of our rules, as to whether or not that was a good document that was produced by AI. AI triggers all sorts of concerns regarding competence and diligence, and even billing and billing for that time. And in this instance, yeah, I would say Brad has to disclose that.
Well, Kevin?
Yeah, I agree with
something you teach about every day now.
Sure. Well, I've taught, if I'm not teaching, I haven't taught professional responsibility lately, but I've taught it. I would say yes, I would agree with Judge Marubio, and I would pull out or flag for us at least Rule 4.1 that says a lawyer shall not knowingly make a false statement of material fact or law to a third person. Now, I guess maybe Brad's defense might be if he's just submitting it that he's not knowingly aware that there could be problems at least with this. But I think you know he's got an obligation at least to tell the partner who's going to present this or file this in court. And then I also think that this kind of tangentially raises competence issues too. You know, and we're going to talk about that a little later, I believe.
Yeah, I'm gonna, I'll ask a few more polling questions, but I'll just flag right away because it's so timely. I want to say it was a year ago in New York, there was a case called MATA versus Avianca, where not only did a lawyer submit a brief that was developed by by AI chat, that all the sites were wrong. The sites were made up. There were no such cases. The conclusions of the phony cases were incorrect, and the lawyer got sanctioned for it, and then did it again in a rehearing. Well, just yesterday, Law 360 is reporting that an AI-generated fake case leads to sanctions there. It was a wage suit, and the person was acting pro se in the fight and did the same thing in a case in a Missouri appellate court. And the courts are all over this stuff. But once again, the sites were phony. The arguments were phony. The propositions that were the conclusions that claimed in the case were bad, and lawyers were sanctioned for it. And this is something that we're going to see an awful lot of coming forward. I think also in another polling question would be, it later comes to mind that Brad did not shepherdize or check the cases cited in the motion, and two of them actually don't exist. What are the possible consequences for Brad? Can he get dismissed from his firm? Is a verbal warning enough, given that he's a new associate? Is a written warning that if he performs this way again in the future, is that enough to ensure that he stays with the firm? And if he uses such platforms, to be sure to check the sites, because that's going to come up in the future, isn't it? That this AI is not going anywhere. And like for an example, Thomson Reuters, they're promoting research using their platforms and AI. Melissa, are you seeing anything at the board on these things?
We are, as a matter of fact, and I just got back from the National Organization of Bar Counselors meeting, which was in Long Beach this time around, and we reported on our very first attorney disciplinary case, beyond just the sanction cases that you astutely referenced, Bob, that involved attorneys who were sanctioned for these types of cases where we see case law being cited that was the derived from what is known as hallucinations from the AI platforms. AI will just spit out whatever case law that it could even make up out of whole cloth. And so when these attorneys go ahead and rely on those in court filings, and it can result in sanctions at the court level, whether it be at the federal court, as you mentioned with the Avianca case or the Missouri matter. In the disciplinary context, then the individual regulatory authorities in those jurisdictions have to take a look at the rules of professional conduct and determine if they've been violated by this conduct. And in Colorado, in the case of In Re Craybill that just came down in about September or October of 2023, an attorney was disciplined and received a suspension from the practice of law beyond just the sanctions that were meted out at the court level for relying on a ChatGPT generated case law in a brief that the parties immediately recognized was false case law. And so, in addition to the consequences that are listed in these hypotheticals, you have to consider another consequence being violating the rules of professional conduct, particularly those related to candor to the tribunal and, not making false statements in pleadings, and consider that there may be disciplinary consequences as well as the obvious consequences here that might result within the firm structure. And if I may, I would also suggest, if you look at the way that this problem is drafted, and it's very similar to a lot of the cases that we're seeing in this regard, you got to look to firm culture. And if this associate was feeling pressed for time or otherwise stressed out, and resorted to ChatGPT as a quick fix, sometimes, while certainly an associate who's lying to a partner cannot be tolerated, and they may be dismissed from the firm pursuant to individual employment contracts and whatnot. I think any firm that has this type of thing or experiences this type of dilemma has to look inward and say, what are we doing as a firm culture to train our attorneys to make sure that they are not that they understand the ethical utilization of these technologies, and so that they're not feeling pressured in this way so that they make bad judgments.
I mean, look, are we saying that there's something improper per se about using AI as a tool, or are we saying that if you're going to use it, there has to be a responsible way of doing it, and there's an irresponsible way of doing it?
And
what do you think, Judge?
I think in the future, we're going to be saying that not using AI is going to be incompetence and not keeping up with the profession. I think we're going to have a duty to learn how these systems work, how they gather information, how they store information. I mean, we use Lexis and Westlaw freely, and that's an AI system. We use natural language searches, and we've adopted that, and we accept it. And we accept it because we believe that there's no confidential information being stored in that system. And we've been assured by those systems, but we've learned how it works. Now, we don't know that about different AI platforms. We don't know if privileged information is being stored, how it's being used, how it's being spit out in future answers to other people. So we have a duty, one, to understand that. And two, we probably do have a duty to use AI systems where it could save our clients some money, where it could be more efficient, even more accurate. Using an AI system, for example, to search a contract for inconsistent use of a word might be more accurate than having a human do that due to fatigue. So I think that it's going in that direction where we are going to be expected to understand how it's used and how do we comply with our rules within that diligence and competence.
Well, you just mentioned money. Joe, pull up polling question E, because here, Associate Brad, we've now find out he bills the client for 3 hours of work because of what it would have taken him had he done the work himself. And actually, it took him 1 hour to complete the work. But since Brad invested in the chat BOT, he feels, and the firm did, he feels he can charge the time it would have taken, given that he was smart enough to find a shortcut. Is that ethical? Answer A, yes, provided he explained that he did it, what he did to the client, or B, no, it's double billing and violates the rules of professional conduct, or C, Brad should never be penalized for using technology to benefit his client, and D, it is unethical to charge more under these circumstances when the final draft took Brad only an hour to complete. I don't know. Professor, what do you think about that?
This is an interesting question, Bob. My initial feelings were or was that it looks like double billing, but it really isn't double billing, because double billing would be billing two clients for the same work product or something to that effect. But the rules with regards to fees suggest or indicates, and I'm going to jump back because I think that answer choice A would be correct. Yes, provided that the attorney explained what he did to the client. So as long as the attorney is upfront and is telling the client that I'm using this new technology, for instance, I'm using Lexis or Westlaw, and then because of the efficiency of the technology, I can, I can do things faster. I think, and the client is okay with that, I think it would be appropriate. I'll share with you, Bob, when I was in private practice, I represented Ford Motor Company in the state of Kentucky, and Ford Motor Company felt, which I thought was very interesting, that it was not getting its fair share of work out of us unless we used Lexis and Westlaw. And so, and that was back way back, a couple decades ago, several decades ago. So Judge Marubio pointed this out. I agree with her wholeheartedly. I'm a little averse to to AI, but I do think it's the wave of the future. And when I think of it and legal research, it's no more than just a finding tool, similar to Digest, similar to using Lexis or Westlaw and using the Boolean searches and those kinds of things. So my thoughts, at least here, would be that as long as the attorney is upfront with the client and tells the client exactly what he's doing, what he's using, and how efficient the attorney is, that the attorney would be able to bill for even more money than he or she might have done if they were doing this or doing the research, without the technology.
Well, let me take this one step further while we're talking about this. Pull up Joe F. Polling question F. So now Brad he's assigned to prepare the document for the client, but he realizes that a very similar document already exists in the firm's electronic brief bank, written by members of the firm who are experts in the subject matter. Brad pulls the document, he modifies it by changing the names, dates, and all that, and then he bills the client for the full amount of time it would have taken had he created the document from the start. Can Brad charge the full amount? Some say yes, that the client has received the expertise of the firm's knowledge on the matter. Some say B, no, this constitutes double billing and Brad can only charge the amount of time he spent on the matter. Or C, yes, it can be done since it would have taken Brad the full amount of time had he created the document from start to finish. And bear in mind that double billing, I believe, is defined as the billing of fees and costs to more than one client for the same work or the same hours, bringing up Rule of Professional Conduct 1.15A17 and 1.15B. What do you think there, Melissa? Are you seeing things like this? Have you seen claims of improper double billing at the ARDC?
Oh, yeah, we see our fair share of complaints related to clients who are upset about bills and attorneys who try to get away with overbilling by claiming this type of double billing, which I think is actually constitutes double billing. In contrast to the original scenario, in which there was some nuances that relates to the utilization and the costs of using a new technology in order to provide an efficient result for a client, which cost could be borne by the client. You have to make sure that you're not being false by saying, I did this work and it took me 3 hours when it really only took me 1. But if you want to charge more for that 1 hour because you're absorbing the cost of ChatGPT, there would be nothing inherently wrong with that. In this scenario, it's just replete with falsehoods. And I think it would constitute double billing because you can't pass along the benefit of a prior client's work to a prior client and charge it as work that's been done to the new client. So I do believe that that would be kind of recycling work product that would be prohibited as double billing.
Yeah, I from a firm's perspective, I mean, I have to agree with that. I think most firms keep, for lack of a better term, a brief bank, right? I mean, I'll tell you what comes to mind for us. We're constantly dealing with forum nonconvenience motions. We're removal and remand issues in the federal system. We write we think some pretty good material around here in response to those things. And we think it's, why would you reinvent the wheel, particularly if you have some really great product from a prior setting? But using those materials is a lot different than saying, okay, I spent 10 hours developing that brief. I'm doing it. I can recharge that 10 hours again. There's something that seems wrong about that. And I think the majority of our attendees today, 78% of them agree. Although there's a strong minority there, that 17% think it's okay.
Bob, we do have some questions from the audience on this particular issue coming in. And some people, Jonathan is asking, notwithstanding the obvious problems with chatbot, if a lawyer gets the aid of it to write a brief, proofreads the brief, and finds that the citations are correct, would he be required to disclose this co-author to the panel?
The co-author?
Yes, in other words, if the lawyer has done everything with the aid of a chatbot of AI, proofread it and everything, finds even that the citations are correct, would the lawyer be required to disclose that AI was a co-author of this brief? Melissa, Judge?
Yeah, I'd be happy to step in. And I think the issue here, because the way the hypothetical set up is it asks if the associate should tell the partner about it. Now, that's an internal firm structure issue pursuant to their individual employment contracts and agreements and training within the firms. So whether or not the firm has in place a structure by which an associate would be expected to inform a partner if they utilize some technology in drafting a brief, that's an individual firm inquiry. Whether or not an associate can utilize ChatGPT or other AI platforms in order to draft a brief and then pass it off as his own, just like any other type of research tool, attorneys do that all the time with LexisNexis materials, and you don't have to disclose, I use LexisNexis to use this. But the reality is the attorney has to make it their own. They have to review it. They have to maintain responsibility for it. They have to understand the risks and benefits inherent in utilizing that technology. And then in some instances, and what we're seeing as a result of the cases that Bob brought to our attention, some jurisdictions and some courts are making rules that say if you utilize AI in any capacity in any pleadings that are brought to the attention of this tribunal, you must disclose that. So be mindful that individual jurisdictions and individual courts may have those policies. But right now, there is no policy that states that if you utilize AI, you have to disclose it to everyone. But the underlying rules of professional conduct would require that an attorney review the work, make it their own as if they were reviewing any other research, and make sure that they understand that they're responsible ultimately for what is put in that pleading, regardless of how it was generated.
Right.
Yeah, go ahead, Kevin.
Bob, I'd also like to add a reference to Rule 8.4 because 8.4 says that it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And so going back to the phrasing of this question, it looks like it's plagiarism. And so without disclosing that it's not your product, I think you are potentially walking a fine line with regards to at least the requirements of Rule 8.4, you know, C and 8.4D.
Well, I'm gonna take the other side of this for a minute.
Mhm.
I mean, because I'm talking about how a real law firm works, okay? And let me go back to my Form Non example for a moment. So we write an 8-page brief that, let's say, one of my senior partners writes. The brief is successful. Now I actually have two new young associates in the office. We assign one of them a new motion that has come in. I say, hey, Yvette Liaison just wrote this brief. It's great. Now she go read that brief. Now she reads that brief. She finds 3 pages of that are of language that are wonderful that Yvette wrote. Now she puts it into the new filing that we're about to file. It's a product of Clifford Law. It's going to be filed with the court. Are you telling me that my young lawyer Courtney Berlin has got to disclose somewhere in a footnote that she took 3 paragraphs that Yvette Liaison wrote in a different brief? I don't think so.
So I understand that. I was going to say that, when I started in private practice, I would use an ICL and there would be an appendix with sample motions and what are considered boilerplate motions. And it was not uncommon to take one of those, you make it your own a bit, but not necessarily that much for some of the really simpler motions. And that's no different than having a form motion come off of Westlaw or a form motion somehow come out of AI.
Well, I don't know if they still do this, but Judge, you remember when we were young lawyers, if you could go down the street to Northern Trust, and I've written one will in my life. It was for my mother, and I God rest her soul. And I went down to the Northern Trust, and they had a book of sample wills.
Yep.
And I took one of those, and I, edited it to fit her needs, and that was a will. Did I have a duty to, in a footnote, Mom, I copped out some of this material from the Northern Trust recommended template? I don't know. Maybe.
No,
We also have a question.
Professor, come on, what do you think?
no, I was just thinking again, though, Bob, in the situation that you just referred to, I think using the form, because what you're talking about is just a form, or with respect to the comments by Judge Marubio, I think it's okay as long as you turn it into your work product. And I really think that the issue that we're grappling with, at least here, is trying to build a client for work that technically I mean, it's your work product because you've taken the form or you've taken something and you've made it your own. But can you build a client for 4 hours that would have taken you when you were a junior attorney, finding your way around the library and drafting it from scratch? And I think that that's the issue, at least the subtle issue in this problem.
Well, and you're right about that. I mean, that here,
Mhm.
doesn't this also raise the sphere of the, some of the dirty little secrets that exist in the practice of law when lawyers, some of whom maybe, let's say they bill by the hour, they go over to the motion call, they're there on one motion, and while they're there, they handle, three others, and they bill out the complete cost of attendance at a motion on each one of the three, so that all of a sudden 2 hours turns into six. I don't know. Does that happen? I don't know. I don't know.
Well, Bob, it does happen. And unfortunately, it happens quite a bit. I will reference, I've written a little bit about this. The ABA has a formal opinion on this that basically says that you can't use recycled work product. And recycled work product would be, using this a same document and just changing names and submitting it, or billing for hours on two different cases. You're going to a case in San Francisco on the plane, but you're to give a deposition or to do a deposition, and then you're working on another client's case. The ABA, for its formal opinion, at least says that that's inappropriate. I think a way around that for attorneys would be to simply tell the client up front, at least, why you're billing the client, the amount. And Melissa kind of referred to it, I think, a little earlier, the efficiencies that you have as a result of having this electronic brief bank in your firm's database, or being able to use chat GPT. Now, if you do that up front, then I don't think you're being dishonest. And I also think that, and this is just my own struggle with this whole issue of double billing, I think a lawyer should be able to bill for his or her expertise in an area. They've acquired expertise. And so if you've been doing, a certain type of practice for years, you can pretty much draft a motion or a pleading fairly quickly. Bob, I'm jumping out. Doctors kind of bill for their expertise, and other professionals are able to bill for their expertise. And unfortunately, at least in the legal academy, we're lagging a little behind, and so that might be something that the ABA may
But
reconsider.
if you go back to the example that I used, where the young associate looks at the brief written by a senior partner on another matter, takes 3 paragraphs, 3 pages, doesn't matter, uses those. Bluntly, I find that perfectly proper and appropriate. That gives the firm's expertise to the second client. What I think would be inappropriate is to then ask that senior partner, by the way, how long did it take you to write those 3 pages or those 3 paragraphs, and then try to add that onto the billing of the second client. I think that's where you cross the line in my mind.
We do have some questions coming in here on this very important issue, and they're asking, is anyone aware of any specific professional organizations that are currently drafting any ethical rules on AI? And what about the issue of firm policy and how important that would be on AI authorship?
There are now advisory opinions coming out of Florida, California. California just wrote a guidance for attorneys. It happened in my news. I saw it in my newsroom a few days ago. It's pretty lengthy, giving just all the pitfalls of using AI and some guidance for attorneys if they're going to adopt it for their law firms.
Yeah, I think to that, I think you need to, this to me speaks to another issue. Look, the membership in all of our professional organizations, ABA, ISBA, elsewhere, seems to be dropping like a brick in water, which is really sad, because the reality is that our professional organizations do the gathering of collective thought on these things and disseminate it, and makes us better lawyers. So I think you're going to find that there are going to be multiple AI task force through the bar associations, through maybe the court systems. We're talking about AI in one context, and I'm telling you that it's a major issue that's going to be associated with discovery in the future. And potential abuses of discovery. I think Melissa mentioned a group that she attended, a program she attended recently. I attended one recently where they showed a witness looking straight at you on the computer screen doing a Zoom. And in fact, that witness was looking off to the left, reading from a teleprompter the answer to the question that the lawyer was typing. This was all a mock thing. But to show you, because this computer program from AI switched the person's face to where it looked like they were looking right at you, when in fact they're reading off of a teleprompter. That is such an insidious danger of things like that. So we're going to see a lot of stuff coming out of about AI, and that's why you all ought to re-sign up for the ABA, CBA, ISBA, all of them. There you go.
One other last question, Bob, and I know we have to move on because both Michael and Laura are saying that there's an assumption here that billing is hourly. But what about selling the document by the hour? Because isn't that what we have to move to? Because then Michael's asking, why can't I sell it twice? Then the same for 10 hours for a brief.
If that's the contract you have with your client, maybe you can. Anyone else, Melissa?
Well, we're actually dealing with it. We're going to, as part of our PMBR program, one of our newer rollouts that's coming out a little bit later this year, we are addressing kind of, I don't want to call it the death of the billable hour, but how AI is going to have implications on whether or not the hourly billing structure can survive, and whether it's the appropriate way to, compensate lawyers for the work that they're doing, given that now we know a significant amount of the work can be generated through AI, or at least streamlined or expedited. And so, it is worth exploring whether or not the billable hour structure is relevant and ethically appropriate, given how much AI can do.
Mm-hmm. Yeah, I don't know if the ARDC has done this, but how about taking it back to leadership, Melissa, that they form an AI task force to, give a special report and direction to the bar somewhere down the line.
We're kind of already on top of that. They love my suggestions, first of all, around here. But secondly, just like any other government agency, but we actually do have an in-house AI task force. Obviously, the Illinois State Bar Association has a task force on AI that's already promulgated a report that has been distributed to President Kasserman, as well as some of the committees on the ISBA, as does the ABA. But what we're doing internally at the ARDC is we've created a sandbox, if you will, of AI, so that we who are responsible for educating and then ultimately regulating lawyers understand how AI works, so we can understand the realistic, approaches that utilizations that attorneys are grappling with, because we recognize that it's causing a lot of consternation. People want to stay ahead of the times, but they want to make sure that they're doing it ethically. And so we have a small group of attorneys here who are working with AI and have almost like a sandbox where we can kind of play around with it and make sure that we recognize the risks and benefits inherent in that.
Well, there you go. Food for thought for a program next year. All right, let's move on. Let's change the scene. We're stepping away from AI. We're going down to some more nitty gritty of the things that happen in the courtroom. And in hypo number 4, we have a judge who has just completed a heavy court call on a criminal matter. And although the court is adjourned and many of the attorneys remain on the Zoom call, they're discussing the day's events, and that happens all the time. The judge is physically present in court. The judge is sitting on the bench, and she's on the court computer. However, the judge mistakenly believes that he has ended the live stream of the proceedings. Now, while venting about a particularly challenging case, the judge mocked and ridiculed the lead defense attorney. He stated, quote, "Did you see her losing her mind? She was rolling her eyes and they were getting red, and she was practically hysterical. She is so emotional," end quote. The judge indicated he enjoyed getting a rise out of the attorney and thought that watching the attorney react was entertaining. The judge continued to express his opinion that he did not find the attorney attractive, thinks he's annoying, and concluded by saying, "Can you imagine waking up to her every day? Oh my God." The judge later insinuated the attorney was in a sexual relationship with a younger attorney at her firm who also appeared on the case. And finally, the judge referred to the younger attorney as her pool boy. The judge encouraged other attorneys to also mock the attorneys in question. The judge then realized that the live stream was on and terminated the Zoom session. Wow. Let's get our polling questions going first. The first polling question: does this conduct rise to an ethical issue for the judge given the court was adjourned? Yes or no? There are materials cited in the notes at the end. And then let's go to polling question number 2. Well, that was it. That's the polling question. I mean, hello, this is the real stuff. By the way, I think it was just last week, similar circumstances, a judge fairly new to the bench resigned her position for similar circumstances. I'll start with you, Judge. What do you think about what we just read? Is this hypo?
Well, just to start, just because you're quote unquote off the record, you're still a judge. You're a judge in your personal life and private life, and the ethical rules apply to you. So whether or not court is adjourned, it might mitigate how many people this opinion was expressed to, but it doesn't undo the damage, nor does it undo the violation. I want to start with Rule 1.2, which is promoting confidence in the judiciary. And that rule says, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. So I say impartiality there because these statements have indicated a bias towards a party and actually a whole firm in this instance. It's a really unfortunate level of conduct. And you know, as judges, we set the tone in our courtrooms, and we have a lot of power in setting that tone and what we will tolerate and won't tolerate in terms of what's being said. And when I look at these hypos, I always try to find the line that was crossed when it was crossed. And in this scenario, that line gets crossed when it moves from the general to the specific. There's nothing wrong with venting about the day. Hey, what a long call. Wow, so many motions, you know, thanks for your hard work. I know it was a slog today. But then when it's specifically about people and cases, I think that crosses the line. But I'm just scratching the surface of all of the possible violations in this hypo. I know Melissa and the professor have a few more.
Professor, what do you think, sir?
I think it is a clear violation of 2.8, the Illinois Code of Judicial Conduct, Rule 2.8, which says, a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others whom the judge deals with in his or her official capacity, and shall require that similar conduct out of lawyers that appear before him, lawyers and others that appear before him. So I think this is clearly, I agree with Judge Marubio that the judge sets the tone, at least for the courtroom, and the judge has an obligation, a duty to be impartial and fair, and these facts look as if the judge is making fun of a party, which would clearly be a violation of the judicial code.
Would what transpired be valid grounds for immediate recusal of that judge?
Good question. I think so.
I would think that bias has been expressed.
Mm-hmm.
I mean, especially there was a comment in there, I love his accent, or saying things like Middle Eastern defendants. I mean,
yeah, the statements from a judge can be grounds for all sorts of discipline. And you're right, judges have been disciplined for things such as, oh, I love her accent, or saying blanket statements that most domestic violence defendants are of Middle Eastern descent. Just single statements like that can rise to a disciplinary level. And here you have not just one statement or two, but this encouragement of this sort of mob mentality of piling on this person.
Melissa, do you have anything to add to the discussion here?
Well, only to point out how topical the Clifford Law Offices are in regard to this presentation, because just a few weeks ago, the Illinois Supreme Court added to our CLE rules the rule that a certain number of hours have to be in the area of professional responsibility, and now one of those hours can be in the area of sexual harassment prevention. And we're one of the first states in the nation that has such an obligation hour or allowance for one of the professional responsibility hours to be in that area. And I think this is a type of scenario that speaks volumes to that, where people, judges are people too, and judges are lawyers too. In Illinois, all lawyers all judges are lawyers. And so when we are asking our lawyers to do CLE in this area, it's to make sure that they're aware of how to prevent these things from taking place, whether or not lawyers were party to these conversations and these statements, whether the lawyers were there laughing along with the judge. In the scenario that you pointed out, Bob, in the Oklahoma case, that was a judge texting to her bailiff while they were proceeding in a murder trial, over
Right.
500 text messages that made demeaning and disparaging comments about the genitals of one of the litigants, that one of the lawyers that was appearing before the judge. So, certainly I'm not saying that 1 hour would have absolved or resolved that issue, but at least it makes us all a little bit more mindful of our obligations of professionalism.
There you go. All right, well, let's move on.
Question just here real quick in the hot mic example, isn't it grounds for a mistrial or a motion to recuse the judge and for a new trial, Steve is asking? John?
I think all the above. I think that as a lawyer for any one of the clients involved there, you'd have an obligation to bring it, frankly.
I agree.
Yeah. All right, let's move on because Pam's needling me, even though okay, here we go. Tarzan. Pam, did you make up that name? Tarzan, a lawyer for his client in a commercial real estate litigation action. He enters into an agreement for lawyer's fees in accordance with a judgment that was entered by the court. Before the attorney fee petition can be filed, Tarzan withdraws from the case and the client hires a new lawyer to file the fee petition. Polling question. Does Tarzan have any ethical obligation to assist his former client and the new lawyer in the preparation and filing of the fee petition? Yes or no, or yes, but only to share files and not to help with the new filing as long as neither action prejudices the administration of justice? First off, do we understand the question? This is, I guess, the notion that that when Tarzan withdraws from a case, what is his legal obligation? Kevin, do you have a view about this?
Well, Tarzan, he or she has a legal obligation to at least turn the files over to the new attorney. That's under it looks like it's rule 1.16 B and D. So there would be an obligation to assist by simply not being an obstructionist and holding on to those files. Now, I don't think that there's any obligation, at least, to assist in the actual preparation and filing of the fee petition if the lawyer has stepped down, and assuming that the lawyer can properly step down under the ethics rules.
Judge, do you see it that way?
Yeah, I do. I agree with Kevin. There's never feels good to be off a case, but you've got to follow through professionally.
Yeah, I mean, I think it speaks to not only the client's duty, the lawyer's duty to the client, but it also speaks to a lawyer's duty to the court and the efficient administration of justice.
That's a good point.
So all right, let's move on to number 6. Lawyer LaShonda completed estate planning for a married couple who now intends to get divorced and wants to modify their estate plan. Both husband and wife would like to continue to have LaShonda as their individual attorney in this matter, even after the divorce is complete. LaShonda did a good job of being fair and impartial, and people like her. This is a good thing. All right, polling questions. Can she do so? Yes, provided that there is sufficient informed consent, or no, it's just too risky, or B, can she represent one of them? Yes or no? Maybe if there's consent, writing that also excludes an exit strategy. And then I'll throw in a twist on the facts after we discuss this a bit and get a polling question. So first off, can LaShonda serve the way that it's being described as attorney for one of the people? Melissa, what do you think about that?
Well, it's a conflict of interest pursuant to 1.7, but it's a waivable one. And the waiver in aspect of that rule indicates that if there's informed consent on the part of both parties and they agree to waive the conflict, then she could proceed. But she's got to be mindful of keeping, issues confidential and not kind of violating the duties of loyalty and fiduciary responsibilities that she has to both clients in that matter. From a practical perspective, I don't know that it's the best practice advice to continue on. It just seems like, human nature is such that it might be better off for her to get out of that representation. But technically speaking, it could be waived, that conflict, if there is sufficient informed consent.
Yeah, I think the majority of our audience agrees with that. Kevin, do you have anything to add to that?
I would agree, but looking at the other answer choice, B, it's too risky. I would be very mindful of the fact that it could get extremely, it could become very tricky. And so if I were the attorney, I would just be mindful of that. And at a certain point where it looked like there could very well be, interests that, are adverse interests, at least on these parties, I would probably advise I'd either step out or advise one of the clients, one of these folks, to get their own attorney.
Yeah, and I think if they said, well, I want her, and then well, I want her. Well, if they couldn't agree, then I think LaShonda's got to say, you can't. Neither one of you can have me.
Mm-hmm.
Let's take a twist here and then turn it a little bit. This happens, I'm sure, in firms, particularly family law firms, where an attorney meets with a new client who seeks a divorce, and unbeknownst to that attorney, another lawyer at the same firm is meeting that same day with the other divorcing spouse. Question: can either or both attorneys move forward with representation? Yes, no, or yes if both clients receive sufficient informed consent and agree to waive any potential conflicts of interest and allow a wall of that separates the representation. Can that happen? So what do you think, Judge? What do you think? You probably had stuff like this in your courtroom.
So, I know when we discussed these hypos early on, we came to an agreement as a group that there could be informed consent in this. I still think this still makes me so nervous to say that this could happen. It depends on so many variables. How many protocols are in place in that law firm? How separate are these cases really going to be? I think it's a bad idea, but I think that Melissa had convinced me that it was waivable.
Oh, this one I don't think was a waivable one. Sorry, I don't mean to.
Okay.
I think we might have skipped one of the hypotheticals. Sorry, I didn't mean to.
No.
Okay.
I just want to make sure that it's clear, because I think in this particular context, we might have skipped over one, but in this particular context, if it's two opposing sides in the same matter, that's not a waivable conflict pursuant to 1.7. Right. So if it's a situation in which it involves an assertion of a claim by one client against another, then that's not waivable. But there are circumstances when it would be a waivable conflict. But like you said, Judge, even if it is waivable in some circumstances, it doesn't mean you have to do it. It just doesn't make good sense to do it that way.
Right. Yeah, it probably is fact driven. I see that over half of our audience thinks that it's something that could be worked out, but a strong no is out there, and maybe it's really a function of the exact fact pattern. If we were having our live audience here, maybe, and even though we're not, maybe one of our listeners who practices in this area and has had this experience could text in an answer to Pam about what really happens in the trench of firms that maybe come across this issue at times. We can come back to this if we get an answer or two from our friends. Okay, well, thank you for that. Let me move on. Lawyer Jack, an immigration attorney, has always been a good neighbor and friend to the family next door. And one day the neighbor sees Jack outside and approaches him about a criminal matter in her family. Jack admits that he doesn't practice in that area, but offers her some legal advice that might be helpful. Polling question: A, has an attorney-client relationship been established? Yes, no, or possibly. Lawyer Jack is having second thoughts about what he said, and he thinks, and in fact, he might have given some inaccurate information to his neighbor. So therefore, B, should he memorialize his over the fence conversation with his neighbor? Yes or no, or maybe. And I guess so that gets to, should a lawyer admit that he or they can't assist and refer the person to another lawyer, knowing that that attorney will charge a fee? A, never, it's not the neighborly thing to do, or B, always the lawyer took an oath, which applies even when given advice in his driveway, or depends on whether you think you might get sued if you are wrong, or D, no, unless there's a written contract, no attorney-client relationships exist. E, yes, a lawyer realizes his or her boundaries, and they can't currently give advice. Wow, there's a lot in there, baked in there, Pam. So let's go back up though and take it number one. The lawyer admits that he doesn't practice in that area, but offers some legal advice. Melissa, how often does it happen, Melissa, where the ARDC sees a complaint against the lawyer, who gives some advice, and then it's like no good deed goes unpunished. The advice is taken, it goes sideways, and the people complain to the ARDC. Does that happen? Do you get those cases?
It does. It happens quite frequently in this context. And I think this is also fodder for malpractice all the time as well. I think even more so malpractice, this particular scenario. And while I think, at least in my age demographic, that kind of over the fence advice type of thing is very likely, or that's how we envision it. What is even more likely in today's day and age is that the advice is being transmitted through some social media or technology. And so, whether it's someone's on a blog and they're just answering a question for a potential client or whatnot, I think attorneys would be very well served to understand that whether or not there is an attorney-client relationship such that your legal advice could be deemed, actual reliable advice in the context of a potential malpractice and or disciplinary context, that attorneys would be well served to understand that it's not what the attorney thinks, it's what's in the mind of the client as to whether or not the attorney-client relationship has been established. And so certainly documenting the exchange would be good, but I would take it a step further and say, perhaps you shouldn't be giving legal advice at all, especially in an area that you know nothing about. The realities of life and human nature, though, are that a lot of people will be like, well, it's not advice, but let me give you some guidance or whatever. I would still caution against that because you're exposing yourself to potential malpractice risk by doing that.
Well, certainly, I think the majority of our audience agrees with you. And then to the next question, should that conversation, over the fence conversation, be memorialized? The answer to that was a strong yes. And then I guess, should the lawyer admit that they can't assist and refer the matter to another attorney, knowing that the attorney will charge a fee? And I think once again, the strong majority of our audience agrees that, best to send the person to someone reliable who knows what they're talking about. Although there's some people who think it's the neighborly thing to do. If we got over 5,000 people here today, you got 8% think yes. So you got, let's see, 7%, 8%. So you've got 350 people. No, now we're down to 6%. It's diving. Fewer and fewer people upon reflection think that it's okay to do this.
They need to take your advice, Bob. No good deed goes unpunished.
There you go. Okay.
And Bob, it happens all the time, especially for new lawyers. As soon as someone in the neighborhood finds out that you've been admitted to the bar, they come over and they start asking you all these legal questions. Family members, friends, people, at the law school, I have students who will meet me after class and ask me about some legal things. And I smile at them. I do not give advice, but I encourage them to seek legal counsel if, in fact, they think that they have, a legal cause of action.
Yeah, I know that our practice here is that we really refer people. We keep a list of lawyers to whom we refer matters and these kind of things because, it just, in the end, if you're wrong, you're doing somebody an absolute disservice, and you don't want to do that. They came to you because they trusted you. They rely on you, and we should, draw the lines between what we do and we don't know. I mean, that's giving them a service, putting them in good hands.
Bob, you have a question here asking, but how does this apply to pro bono clinics or similar pro bono opportunities like the ABA offers, free legal answer programs?
Well, if I understand that question correctly, if you're doing something, the pro bono work, then just because you're not getting paid doesn't mean that it's an excuse for not having competency. If you're going to accept a pro bono assignment, it's your obligation to be up to speed on that practice area. So I kind of draw a difference between free legal advice on something that I don't really know about and free legal advice when I've been tasked on and I've accepted a representation. I don't know, Melissa, do you see it otherwise? Or Judge, do you see it otherwise?
No, I mean, essentially this over the fence conversation is pro bono legal advice. Technically, that's what the neighbor's asking for, is some free legal advice. And I think that's right. You've got to be competent and diligent. Just because you're volunteering doesn't mean you can give bad advice.
Right.
I think it's a common misconception that the exchange of money or a fee contract somehow plays into whether or not an attorney-client relationship exists. And that couldn't be further from the truth, despite what Better Call Saul says about, here's $1, now you have to keep my privileged information or something. The exchange of funds, the written fee, the existence of a fee contract, none of that is relevant to whether or not there is an attorney-client relationship. And so whether or not it's pro bono work or not, those same duties are still owed to those clients.
Well, Bob
Sure.
is offering that no attorney is ever off the record. So that's his comment to this.
That's a good point.
Well, say that again, Pamela.
An attorney, well, Bob Fioretti is saying that no attorney is ever off the record. So really, technically, you're always like on the job.
There you go. That's the politician in him, because he's always out there. He's on the record. Hello, Robert. Okay, let's move on. I think I covered that. Well, yeah, let me add a twist in here. Well, it says, what if Jack is a newly appointed attorney? Does that change the outcome? No. Another twist, Jack is a newly appointed judge. Does that change the outcome? Well, I have an answer, but Judge, well, are you asked for legal advice by your?
I can't go to a family function without being cornered for legal advice, that's for sure. And I should carry a copy of Rule 3.10 with me. First of all, I love a rule that leaves no room for interpretation. And 3.10, as to the practice of law in the Judicial Code, says a judge shall not practice law, period.
There you go.
It's so nice and simple.
It solves that problem.
That's it. You can't have that over the fence conversation, and you even have to be careful about referring someone to a lawyer.
There you go.
Yeah.
Okay. Moving on. Number 8. You represent a client involving a real estate tax appeal for a building that was demolished. The Board of Appeals still has it on the books as a built home on the property. The fees required to conduct a proper appeal in the matter to correct this error may cost more than the potential tax savings to the client. Okay, polling question. Can you charge for the appeal work, or do you have an ethical obligation to your client to do the work at no cost? A, you have to do the work at no cost. B, you move forward with the appeal and work out the cost with your client later. Or C, you consult with the client about their objectives and the immediate financial benefit versus long-term costs involved. Kevin, what do you think about that one?
I think that you can charge as the attorney that you would be able to charge the client for the extra cost of the appeal work. I don't think that there are any rules that would require the attorney to perform that work for free. But I think ethically, the attorney probably should have a conversation with the client and tell the client that's going to cost more to appeal it than, and you might want to reconsider your decision to go forward or to just bow out.
And that raises a curious question to you, Melissa. Does the board ever see where a client says, look, I hired this lawyer. He told me that, it may not be the greatest case in the world, but he's going to charge me. Next thing I know, I'm really many, many dollars underwater. And had I known, I would never have done this. He didn't give me any estimates. He didn't ask me what my budget was. He just blindly let me go forward and I trusted her. What do you think? Does that happen, Melissa? Do you hear about that?
Yeah, I mean, absolutely. We see that in the context of clients who believe that the attorney gave them kind of unrealistic expectations as to the outcome. And certainly when it comes down to fee disputes, if a client's going to claim that there was exorbitant fees or excessive fees charged, and their claim is going to be that the work performed was not required or should have been not performed because it wasn't worthwhile. I agree with the professor, though. I think this boils down to some of the other rules, though, that we already discussed, i.e., communication with the client, scope of the representation, make sure that the client is directing how things are going to go. And as long as the attorney explains, hey, this may not inure to your financial benefit to go this route, there are some reasons why clients may still insist on going that route. If you have one of those clients, I would suggest best practice would dictate you put that in writing. We discussed this. I told you it's going to cost a lot of money. You're okay with that. Then you kind of indemnify yourself for potential claim later of, as you described, Bob, someone complaining to the ARDC or filing a malpractice claim or something like that against an attorney and saying it was an exorbitant or excessive fee.
Yeah, I agree with that. And in fact, I'm talking to a colleague of mine just yesterday who takes on the impossible cases all the time. He says that after the engagement is solidified, he writes a summary memo to the client that sets out, and it's almost an informed consent thing. I told you this, case was going to have these problems, and so don't go complaining when the bad result does come our way. So that's a good practice, certainly. Okay, moving along, number 9. An attorney prepares for a personal injury mediation and submits a thorough statement with supporting exhibits. The mediators and the parties come to the table, and at the introduction of the matter, the mediator quietly tells the plaintiff and his counsel, "It was so nice seeing them at her lake house last weekend," and the mediator looks forward to resolving this matter successfully. In the meantime, the opposing counsel spotted pictures on social media of the two together at what appeared to be a social gathering at a home over the weekend. Polling question. What should this counsel do? A, immediately ask the mediator to stop the mediation and seek another mediator. B, ask the mediator if he intends to be fair to all parties and to be sure of it's on the record. C, petition the court asking that the mediator withdraw. D, proceed with the mediation knowing that the mediator will see the thoroughness of your work and will be fair. Wow. Okay. Well, Kevin, what do you think about that, buddy?
My thoughts would be my personal thoughts would be to ask the mediator to step down, because it sounds, based upon these facts, as if the mediator and the party are fairly close. So I would my answer choice would be A. I do think that B is a competing answer choice. Ask the mediator on the record whether he or she intends to be fair to all parties and have it put out on the record at least. But my initial thoughts would be to ask the mediator to step down or to try to get another mediator.
Well, let me do this. I'll take the other side of this for a moment. Most mediations permit, and by agreement, allow ex-parte communications between the mediator and the lawyer. That's part of the process. Agreed to up front. What difference does it make if that's I'm talking to someone over the phone, or I'm having a little cocktail with them on their porch overlooking the lake? I mean, come on here. Let's get real, Melissa. What do you think? That's my defense to this complaint.
There you go. Well, the difficulty here, there's a line between what smacks the conscience as being conflicting interests and what is or is not violative of actual codified rules. And I think this certainly falls in the former. Whether or not it falls within the latter is going to depend on the individual structure involved in the mediation or arbitration, the rules of that particular mediation service or arbitration service. I know JAMS has some particular rules related to the, appearance of impropriety, whether or not their mediators and arbitrators can engage in circumstances in which, or act as a mediator or arbitrator in circumstances in which there's an appearance of a conflict. The reality, though, is in some contexts, mediators, arbitrators do not even have to be lawyers. I think more often than not in Illinois, they do, and they should be lawyers, so they should be abiding by the general conflicts of interest rules. But, I think this is one that I'm not sure entirely if it would be violative of a rule, but I think asking that mediator to stop and maybe seeking another one might be the best thing to do for your client, because from that attorney's perspective, you don't want to be accused of being incompetent or otherwise failing in your obligations of diligence on behalf of your client if you let that mediator go through and there was a clear appearance of impropriety.
Yeah, well, here's the thing. I think when I first read this one, I mean, I think all of us have an immediate reaction to it. But if you think about it, number one, there are disclosure issues. I mean, certainly if the mediator is a lawyer or not matters. That's number one. I think it also matters, is this a mediation and or an arbitration? If it's a mediation, of course, you don't have to settle. You're right about JAMS. I mean, JAMS has rules, and I think others do as well, ADR, where, but on the arbitration side, they say an arbitrator should ensure that he or she has no known conflicts of interest regarding the case and should endeavor to avoid any appearance of a conflict of interest. And they have rules that go on from there. So to my mind, I mean, I would not, if I heard that circumstance, I would be suspect of it. I wouldn't overreact, though. I'd ask for an explanation. So I think it's all going to be very case specific. But let me ask you this, Judge. What if the mediator in this instance is a sitting judge? I mean, do judges actually sit as mediators nowadays? Do you pretrial conferences where you run the place? What's the deal here? Are the rules different for you?
They are. So I think it's rule 3.9. It's not as catchy as 3.10, but essentially judges can't be employed as arbitrators or mediators separate from our official duties. So if we're settling cases in pretrial settlement negotiations, then cases that are in front of us, that's different. But we cannot independently be mediators and arbitrators. And in this raises all sorts of issues about social media and the new judicial code. And we have incorporated essentially social media into every possible rule that judges have to follow, meaning that if you can violate the code in person, you can also violate it online. And having a personal relationship, having someone over to dinner at your home might call into question whether or not you could be fair and impartial to that person. And certainly the other side is, like you said, there's a disclosure issue. The other side having the right to know that. And here it's not just that statement that it was nice to see you, but then also that photo posted online. And if that were a sitting judge and those photos appeared, I imagine there might be some motions to have the judge take it off the case.
So does that mean then for the mediation process, we should have a social media protocol where one, lawyers should not be on social media, or two, judges should not be on social media, or three, lawyers and judges should not be friends or connect on social media, or D, lawyers and judges have personal lives and it's okay to post events and personal items of interest that they choose, if they choose to be connected on those platforms. And then lawyers and judges need to use common sense in making connections on social media platforms. I mean, there is paragraph 4 of the Illinois Code of Judicial Conduct that speaks to judges' personal and judicial activities and how they're to be maintained. I mean, what's wrong with lawyers and judges being social? I mean, have we taken too far?
comment from somebody even in Iowa who says that, because we extend to 5 states here, that the Iowa Supreme Court allows attorneys and judges to be friends, so why not mediators? And to the judge here, Kenneth writes, mediators in Illinois do not have to be attorneys. Indeed, family courts frequently have social workers as mediators.
So, yeah, Bob, there's nothing wrong, right, with being social. In fact, the judicial code encourages judges to stay in the legal community, be involved, to teach, to be involved in bar associations, take leadership roles even. The fuzziness, right, comes between when there's an actual personal relationship. And I'm not saying that because you and I are Facebook friends that we're actually friends in real life, but that could give the appearance to an attorney or a party who's not friends with me on Facebook that you and I have a special relationship.
Well, certainly in the practice of law, an awareness of social media and its use is essential. I mean, whether it's I mean, we check, for an example, when we get new clients, we get permission to do this, of course, from them, but we want to know what they've been posting on social media. I mean, you know, when someone comes into us and they say, I've got these horrible injuries, and then we check their social media and they're skiing in Breckenridge this weekend, we want to talk about that. And I'm sure there are other instances, you know, that we could all talk about and identify where you're dealing with similar things. But to me, you know, we do mediations here, and any of the lawyers on listening in today, I'm sure you all do mediations all the time. I think the common sense thing is to make sure that there's some transparency in the relationships and disclosure about the relationships, because otherwise there's not going to be any trust. And when there's no trust in the mediation or in the arbitration or in the process, then you're not in a good place, and you ought to get out of it. And I think you owe that duty to your client. So, okay, well, let's move on a little bit here. Judge Anthony was involved in a minor traffic accident. Oh, this is a good one. Judge Anthony was involved in a minor traffic accident. During the investigation, the officer noticed an odor of an alcoholic beverage and open alcohol in the judge's vehicle. The passengers in the judge's car also appeared to be under the influence and are both judges. Judge Barney asked the investigating officer, "Do you know who we are? Don't you recognize us?" And Judge Anthony helps you all the time. He runs the criminal courtroom. You should be giving him a break. The officer continued to investigate Judge Anthony for DUI, which outraged Judge Barney. And Judge Barney proceeds to yell at the officer, threatens to sue him, calls another police officer to ask the additional officer to intervene. Then Judge Carter gets in the act and is also in the car and refuses to answer any questions and does not cooperate with the police. This is a criminal defense lawyer's, you know, best case here. Where are we going? All right, so Judge Anthony took standard field sobriety tests on the scene. The officer determines he has demonstrated clues of consumption and impairment. Judge Anthony is transported to the police station where he refuses a breathalyzer test, and Judge Anthony is charged with DUI. During the investigation, Judge Anthony made several statements to the officer. Judge Anthony stated that he has been struggling with alcoholism. He knows he drinks too much. He drinks all day and has been trying to stop. Wow. What are some of the issues? Polling question. No poll. There's no real poll here. But Melissa, or no, stop that. Judge, could you jump in here and give us your insight as to what are some of the issues that we're looking at here? There are a bunch.
There are. It's chock full of issues. So I think if we just go chronologically, looking at Rule 1.1 of the Judicial Code, a judge shall comply with the law. We've got an allegation of the great equalizer of DUI, the crime that cuts across all segments of society. And he's clearly impaired. He makes admissions to that. So that's number one. And that's Judge Anthony and possibly Judge Barney for being a little bit aggressive with the police. Rule 1.2 also comes in, which is promoting confidence in the judiciary, and that requires the judge to act at all times in a manner that promotes public confidence in the independence, integrity of the judiciary. So that's definitely Judge Barney. And then Rule 1.3, avoiding the misuse of the prestige of judicial office. Anytime anyone feels compelled to start a sentence, confrontation with, don't you know who I am? We know we're treading into a violation of an ethics rule. And I know we want to also talk about 2.14. And I think Melissa and Kevin, we're going to get into some of the impairment issues that are so obvious here.
Melissa, what'd you see here?
Sure, I agree with the judge wholeheartedly. There's a lot of issues that pop out in relation to this matter, and not the least of which, of course, is the underlying human nature aspect of this. Is someone struggling with the disease of alcoholism, clearly, and we as a profession, we need to grapple with that and how we handle that and how we simultaneously protect that particular member of our profession who obviously became a judge, so they obviously had some kind of a distinguished career, but also protecting the public and protecting the legal consumers in the various jurisdictions and states in which we live. So we've got to kind of create a little bit of a balance. So, not to suggest though that judges or lawyers or anyone should be able to get away with this kind of criminal conduct, because at its heart, it is in fact criminal conduct that needs consequences. What I would want to point out from a lawyer's perspective, and Judge Marubio did a great job, and I know she was on the committee that actually drafted the new judicial code. But for those of us who may never seek to be on the judiciary, it's really relevant for lawyers to understand and have a working operational knowledge of that new code, because we have that Himmel rule in Illinois, and it's an ABA model rule now, 8.3, but an often overlooked aspect of the duty to report other lawyers for misconduct is 8.3b, which is a lawyer's duty to report judges if judges have violated the rules of judicial conduct in situations in which that raises a substantial question as to the judge's fitness for office. So while we may think, well, we'll never have to deal with that, we're not a judge, the reality is that if you're privy to this and you haven't, if you know that a judge is suffering from alcoholism or has some other, impairment that is going to raise a substantial question as to their ability to be fit to be a judge, you may have an obligation just like you would have a Himmel obligation if it was another attorney. So you kind of need to know those rules and have a little bit of a working knowledge of the new judicial code, which I think has done a great job of addressing a lot of these issues and does in fact implicate a lot of social media considerations as well.
Kevin, where does this fit into the classroom?
With this rule, with this problem and the classroom, I think it's a great it's a great teaching moment, I guess, with regards to the fact that judges are just like the rest of us, and that judges have some of the same issues that we have as individuals. As I was listening to Melissa and Judge Marubio both seem to kind of suggest that this is sort of a problem that cuts across all boards, all cultures, all whatever, at least here. And so this is a reoccurring thing. In the classroom, Bob, I think looking at Rule 8.3, I think I would spend some time with the students looking at the word knows, a lawyer who knows, because I think that's kind of, at least it would raise good classroom discussion, because the rule seems to suggest that it's triggered once there's knowledge. And does knowledge equate with, hearsay? Someone tells you about Judge Hopkins or something to that effect. And I think under the rule, I sit on the committee with Judge Marubio, the Illinois Judicial Ethics Committee. I think under the rule, we were thinking that's got to be a little more than secondhand knowledge. That's not going to be good. Or someone telling you over the phone, well, I saw Judge Hopkins or Judge Marubio or Judge Smart, and they look like they were a little tipsy at the out there, or something to that effect. It's going to require a little more than that. And I think that's what I would love to have, at least in the classroom, have students kind of grapple with knowledge.
Right. Right.
Bob, maybe on a little bit of a separate subject, but we do have Richard asking, and when we're talking about the new judicial rules about gifting judges when you have cases before their court, and in particular, he's asking, for instance, with Clarence Thomas before the U.S. Supreme Court, and I don't know if the Judge Marubio would like to address that.
Well, so the U.S. Supreme Court is its own entity in terms of whether or not we can accept gifts in the judiciary. We cannot. We can accept tokens such as plaques or things that don't really have a lot of intrinsic value outside of that commemoration of the award or that moment. We can accept, a small tchotchke for doing a CLE, but we cannot accept gifts.
Yeah, it's
mean,
got to be, I've always understood it to be something that commemorates the moment type thing.
Yes.
Not of great value.
That's right. And hospitality at, regular hospitality at events. So nothing.
So a member of the Supreme Court of the United States might be able to take a private jet or yacht ride, but you can't. That's what we're saying here.
I'd like to say that I've been offered and have turned it down, but it has not come up.
There you go. There you go. Okay, let's turn on to number 11. An adult was adjudicated to be disabled as a result of a slip and fall case. Just prior to this adjudication, the client hired a reputable personal injury firm to represent him in the matter. After a guardian is appointed, the guardian is contacted by the PR firm, but the guardian does not agree with his representations and wants to change lawyers. The PR firm does not agree to withdraw given the representation began prior to the client being adjudicated mentally disabled. Polling question. What are the guardian attorney's obligations and proper ethical responses by these parties? A, the initial firm should withdraw and get in writing that the subsequent recommended law firm is properly appointed and proceed under Rule 1.4. Or B, the initial firm should petition the court and ask that it be allowed to continue its representation since there is no dispute that the representation has been unsatisfactory thus far or satisfactory. Or C, the second firm should petition the court and ask that its firm be allowed to continue with the matter since those are the wishes of the guardian. There we go. Kevin, any thoughts about that?
Sure, Bob. I think this hypothetical implicates Illinois Rule of Professional Conduct, Rule 1.14, which states if a legal representative has already been appointed to the client, then the lawyer, or in this case, the prior lawyer, should ordinarily look to the representative for decisions on behalf of the client. So my thoughts, at least, would be that answer choice C would be the correct answer. The second firm should petition the court and ask that its firm be allowed to continue with the matter, since that is the wishes of the guardian, and the guardian trumps, at least in this situation. The guardian makes those decisions.
Right. I think our audience, if I'm interpreting the responses correct, 65% or so say the initial firm should withdraw and get in writing that the subsequent amended law firm is properly appointed and proceed under Rule 1.4. It's certainly a unique situation. I think it's fact specific because there's a situation that comes to mind where the reason the guardian doesn't like the first law firm is that the guardian is going to execute a litigation strategy with the second firm that the first firm thinks is not in the best interest of the client. So let me go back at you then, Kevin. So in other words, law firm number 2 and the guardian are in cahoots, and they want to go down a pathway that would undermine the best interests of the disabled person. And when the law firm number 1 has reason to believe that's what's going to happen, and they dispute that, and they want that they want to stand as a pro bono guardian of the adjudicated person because they think that the new GAL isn't doing the right job. Have you ever seen a situation like that, or Melissa or Judge?
From a regulatory perspective, we don't quite see this as often as I think general probate courts might have to grapple with these issues. I mean, the professor's right, generally speaking, that the guardian gets to make the decision. But pursuant to Rule 1.14 and the provisions of that rule that were just up on the screen, as well as some of these comments, there are circumstances when, a client who is subject to a guardianship or, is somehow otherwise diminished, whether it be due to age, infirmity, or otherwise, that they're at risk of certain types of, financial injury or wrongdoing or wrong deeds. And so an attorney does have the ability in some circumstances, if there is a risk of substantial physical, financial, or other harm, to take some kinds of protective action. So in the second prong of that scenario that you addressed, Bob, wherein they think that the guardian is kind of acting in cahoots to try to, somehow harm the client, or in cahoots with the second law firm, then I think the firm might have an obligation to step in and take some kind of protective action. And the rule doesn't really say exactly what, but it just got to be reasonable in the circumstances.
Judge, did you ever have anything like that come before you?
I have not. I did not. And, in fact, I'm picking up on what Melissa said. The only, analogous situation are guardians ad litem or child reps, attorneys for the children, that I can think of as an analogy, and that guardian gets to make the decision or the recommendation at least.
Right. Okay. Well, then let's move on to, although I have a question. Melissa, this goes to you. I've had this question for a while, and I'll bake it into this this issue. Let's pretend that the guardian comes in, and now the guardian wants to use a different law firm, and that law firm is from the state of Michigan, and that law firm from the state of Michigan wants to pro hoc into the case. Now, query: I don't think, or I do think, that the state of Michigan does not have the same CLE requirements as do the 5 states represented here today. Why should a lawyer from Michigan who doesn't have CLE accreditation, be able to pro hoc into a case in Illinois where they, by definition, don't have the CLE credential that the rest of us have to have? Is that fair or appropriate? Has that issue ever come up at the ARDC?
Not only has it come up at the ARDC, but it's a huge issue right now being contested at the ABA level as it relates to Rule 5.5. So you're really onto something, because
let's talk about that.
Yeah, it's a hot button issue.
Please explain.
Well, making clear that the ARDC takes no position as to the recommendation for changes with respect to Rule 5.5, but 5.5 is the rule that deals with the unauthorized practice of law and multi-jurisdictional practice. And so in Illinois, we have certain provisions where an attorney from out of state can come in on a limited basis, commonly referred to as pro hoc, like you said, Bob, although we now have kind of centralized all of those petitions for limited license with the ARDC. So no longer does someone petition an individual tribunal in order to get that limited ability to practice before them, but now that petition goes to the Illinois Supreme Court via the ARDC, and we monitor that limited ability to practice on limited circumstances. But certainly 5.5 is the rule, and it's an ABA promulgated rule. So Illinois has a similar provision as the ABA model rules, prohibit someone who's not licensed in a jurisdiction and doesn't have that kind of limited ability to practice from practicing within that state. Now, what the ABA, it has not yet gone to the full House, but this is a rule amendment that has been promulgated to many of the ABA committees and was up for consideration at the recent ABA mid-year meeting that just took place 2 weeks ago, in which certain groups are advocating for basically the elimination of any licensing requirements for out-of-state lawyers, meaning if you're licensed in Michigan, you should just be able to come into Illinois and practice law regardless of whether or not you have this pro hoc or other limited licensing ability. It's promulgated by certain groups that I think are well-meaning in that they are looking at this as an access to justice issue. They are looking at it from the perspective of we're in a day and age now where borders are kind of disintegrating with more technology and the remote and virtual practice of law opportunities that have been increased exponentially post-pandemic. So I think it's well-meaning, but I think, Bob, you brought to light a very good reason why maybe we should take a hard look at whether we should completely dissolve this kind of requirement as far as you should only practice in the jurisdiction in which you're licensed, because different jurisdictions not only have different CLE requirements, but look at now, recently in the news was the state of Oregon, they're doing away with the bar exam. And Wisconsin's another state, they're a diploma privileged state. So, not only do different attorneys in different states have different obligations as it relates to CLE, but also just generally whether they did or didn't have to take or sit for a bar exam. Like what's the barrier in each state to get into the practice? What are the minimum levels of character and fitness and competence that each state requires? And I think you're going to find 50 different answers to that question. And so just eliminating the ability to, the requirement that you have to be licensed in that state, I don't think addresses some of those concerns. And so, it's an interesting question that's kind of hotly contested right now.
Wow. I had a situation once where it was a retrial of a case that was caused by, the reversal was caused by the improper conduct of a lawyer from Ohio, and his improper conduct denied the plaintiff a fair trial. That there was a not guilty. We took the case, took an appeal, got a reversal, and that lawyer showed up again for trial number 2. My first motion was to revoke his pro hoc. The judge took it under advisement because he really didn't want to grant it, but he took it under advisement, but the lawyer didn't do any of the bad things the second trial that he did the first trial. And we got a nice result. So there you go. Let's go on to number 12. Yes, Pam? Go ahead.
Question, if you can, from the audience here, and that is Leslie is asking, since case law says that a person doesn't need to be adjudicated disabled in order to be deemed incompetent, what if the first was the first retention not proper in this last hypothetical we just did, if Sonia wants to put it up, because the first lawyer was retained after the injury?
I mean, I think that's a great question. Certainly,
Melissa
yeah.
knows.
It's,
Is that
no,
true?
so in other words, the fact that's being changed is that the lawyer was hired by an incompetent person to begin with. So, right, Kevin, go ahead.
That's an interesting twist to this scenario. I would think that you could challenge that lawyer's representation of the client. So the initial firm could at least step in if the initial firm. I would think that you could challenge the representation of that lawyer.
Well, yeah,
assuming that the client that the client arguably has diminished capacity. It looks like it, or whether it looks like it, or whether or not it's been adjudicated.
Well, again, I think it's a fact-specific issue. It's a great issue and great question. Thanks for asking it, because by definition, we're saying the individual had a traumatic brain injury, TBI, right? And so was that person properly of capacity to hire the lawyer in the first place? And so maybe this whole idea that the guardian was being appointed was a very proper thing. Our facts don't tell us how the guardian came about, but let's say that the family encouraged that. And then now this guardian sees, well, wait a minute, the lawyer number 1 knew that Charlie was a TBI victim and really not capable. They shouldn't have taken the case in the first instance, or they should have sought, to come to the family with the appointment of a guardian. And Charlie, lawyer number 1 is the bad actor and ought to be replaced. So, I could see that scenario, and that's something that again is very fact specific to the case. All of those instances It just need to be, you have to peel it back as to, what are the given details that we're working with.
Right.
So,
And Bob, I think it raises, 8.4 misconduct. If the initial lawyer, in a sense, is taking advantage of that client,
right.
you know,
Yeah. So there you go. We took the same fact pattern and we twisted it so that we had first off, the guardian and lawyer number two were the wrongdoers, and now we got it that the first law firm those are the bad actors. So uh give me the facts and we'll give you the right answer, correct? There we go. Okay. All right, let's move on to number 12, Pam. Pamela.
Can you
Hey,
see it?
Pam.
It's up on the screen. It's up on the screen, Bob. Can you see it there? Hypothetical 12, an elderly
Oh,
couple?
yeah. Okay. It didn't come up on my screen.
Okay,
Thank you.
sorry. Thank you.
No, I got it. I'm with you. Okay, number 12. An elderly couple has children. Some live close by and other adult children are in different states. The distant children visit their parents and take them to an attorney to prepare an advance care planning document. However, the local children had previously taken the parents to a local attorney and gotten an advance care document completed. The elderly couple takes a turn for the worse, and the adult children, both distant and local, start fighting over the couple's care and assets. Polling question. Which document prevails? The one that was completed first? The one that was entered into when the aging parents were of sound mind? The one that the parents tell the court during litigation is the one that they want? To be effective, the parents must have the capacity to understand and to appreciate the nature of the advance and directives and just what they are signing. Polling question number 2, is it too late or can an attorney intervene now on behalf of the grandchildren? No, it's not too late, or B, the grandchildren have no standing to intervene because it's their parents, the fighting distant and local parents that are involved. Wow. Kevin, have you dealt with this in your practice?
I have not, Bob, but I think, at least with regards to the first question, I think it's the assuming that the previous children who had who um, set up who set up the directive, at least on behalf of the parents, assuming that the parents were acting, or the parents were in full mental capacity. I think that one's going to trump. There's nothing in the facts that indicate that, at least at the time in which either set of children sets up this directive, that the parents are not acting with full mental capacity. So if the previous children, the first group sets it up, and the parents have acted under full mental capacity, I think that would be the one that would trump.
Well, I think certainly our group agrees with you. The majority of our audience agrees with you. Judge?
I was going to say the parents don't even recall that they had that first set of directives done. So it calls into question their memory, their cognition during this second episode with the kids of theirs who are from out of town. They don't even recall they've done this once before.
Uh-huh. Melissa, has an issue like this come before the ARDC at all?
We don't see it specifically with respect to the kind of dueling wills or whatnot, but what we do see is attorneys who will fraudulently notarize or otherwise witness testamentary documents, and then obviously the testator's passed and everyone's fighting over which one is if it's a legitimate will, if there was a pre-existing testamentary document, and so we see how kind of attorneys' misconduct really gets kind of tied into an already emotionally charged circumstance, and oftentimes doesn't make it better, if you will.
Well, and I think that's a topic in and of itself worthy of conversation. I mean, what is the role of the lawyer here to, just the community and the civil justice system? I mean, doesn't the lawyer have an obligation when he or she comes upon like in the second instance here, I guess an argument is being made that by the time the new document was signed, the aging parents could arguably not have been of sound capacity. And did the lawyers there,
Right.
know that? And right, I think that's what you were saying, Kevin, right?
Yes.
Um, and then the grandchildren come along and they
Sure.
want to, they want to be involved. Judge, when in your time on the bench with these kind of fact patterns, was there anything like this that you ever saw, and how'd you deal with it?
So I've been lucky enough to avoid an assignment to probate, and deal with these because these are very emotional and contentious issues. So I don't have any real experience to share.
Yeah. When we were talking about this fact pattern in-house, in advance of this, number one, we concluded as I think the majority of our group does, that the grandchildren don't have much standing here to intervene. Certainly, that's going to be fact driven, but at least on the face of it. But when we were all done with this, we got into a discussion about lawyers and law firms and just the whole idea of mental health. Melissa, could you tell us? I mean, what's the latest and greatest in terms of the problems the ARDC is seeing right now with lawyers and mental health issues? Because that's we've been talking about whether or not we need a standalone program on that from the firm's perspective.
Yeah, it's certainly something that is of great concern. We see it not only in the aspect of attorneys who are suffering from mental health dilemmas, but also kind of corollary issues related to potential chemical substance abuse or disorders. And then obviously we've got this other kind of impactful I won't say it's an epidemic, but I know the ABA has classified it as an epidemic of aging lawyers, and dealing with, respectfully dealing with lawyers who are aging out of the profession, kind of have to be handled in the same category of those who may be suffering from mental illness and whatnot. Now, I'm not saying age equates to mental illness in any sense of the word, but certainly when we're looking at regulatory work and the work that lawyers do, the older lawyers get, the more statistical statistics would indicate that they may or may not be suffering from age-related dementia issues or something like that. Now, the ARDC, from our data, we've even changed how we classify lawyers, and just general across the board, we used to keep our data on how many licensed lawyers are over the age of 80, and we stopped it at that. And then it was like, 0.5% of lawyers were over, all the 96,000 lawyers in Illinois, 0.5 or something were over 80. Well, now we've even broken it down, and our last category is lawyers over the age of 90, and 0.2% of all Illinois lawyers are over the age of 90. So certainly the ARDC is not in the business of telling lawyers when they need to retire. And obviously this is a subject of national conversation without getting political here, but certainly people can practice law well into advanced ages, and I'm not going to tell you when you got to get out. But if then, because of your advanced age, you're suffering from age-related dementia or other mental health issues or emotional health issues, it becomes a regulatory problem and a client protection problem. We've got to protect the legal consumers. We've got to protect the judicial system. And so the Supreme Court in Illinois has given us various tools to help us kind of show those attorneys kind of gracefully to the exit door. We've allowed them to retire sometimes with charges pending and things like that.
All right. Well, that's going to be a good way for me to pivot away from politics, because everyone involved on the screen and all of our audience listening, we all know what we're talking about here. But so let me pivot away from that and ask you this question. On the ARDC renewal form, it asks the following question: does your law firm have a succession plan? Query: why does the ARDC ask that? And I don't want to put you on the spot here, but B, what is the significance of yes or no? Can you speak to that?
Yeah, oh, absolutely. And that's another kind of national push, and something that's of national concern, because there's a distressing number of attorneys that report that they do not have a succession plan. And a lot of them are in small firm or solo practice settings, meaning there's absolutely no safety net for their clients. So by succession plan, we don't need to mean anything like specifically formal, but is there another attorney that knows where the IOLTA account information is. You know, if you keep a safe that has, you know, access to the safe that can access your diary in the event that you are incapacitated and can't make it to court that day. So your clients aren't suffering. So again, it all speaks to this client protection issue, and also so that a lawyer's individual circumstances are not prejudicing the administration of justice. The judicial system can go on, even though attorneys may be, you know, in the throes of some, you know, some matter. And it could be as simple sometimes as we saw in the pandemic. You know, lawyers just get sick and can't go to court. Do you have some kind of plan in place that doesn't that allows for the fact that you have to continue on with your work and your clients, and the justice system has to keep on churning, even though you can't be there to do it?
Well, there you go. Well,
I just want to end with on the last hypothetical. Rich is saying that a good solution in tying to this is that he is, when you have elderly people like this, he used to have the person or elderly people see their attending physician the morning of the day that they are signing any important documents, and the doctor provides a statement that they have the capacity to sign those documents. And
that's a great practice tip. Yes.
Yes. So I think with that, Bob, I
think what I want to do now is to thank Judge and Melissa and Kevin. You've been wonderful. I cannot thank you enough. And to all of our friends who signed into this today, over 5,000 of you. We're so happy to have you participate by viewing it. Thank you for your questions, and thanks for attending this year's program. We hope you learned a great deal in the last 2 hours. We hope to see you again next year, and we've gotten some great ideas out of this discussion for next year and future programming. And on behalf of all here at Clifford Law, and especially my partner, Pam Menaker, my executive assistant, Sonia Petrovska, who are tireless in their efforts to help put this together. Thank you so very much. See you next year. Goodbye now.
Thank you so much. And please be sure to fill out and submit the evaluation forms that can be found by clicking on the handouts print capability tab. And as Bob has said, from all of us here at Clifford Law Offices, thank you for attending, and thank you to our panelists.
Bye, Judge. Bye, Melissa. Bye, Kevin.
Thank you.
Bye. Thank you.
Thank you.